So I want to bring up Sally Kalett, who is our Senior Vice President of Client Services, to introduce and moderate our panel, the Sedgwick panel.
Thanks, Daryl. We've come close to the end of our day, and I want to thank all of our guests and our speakers today. It's really been a very fine day, wonderfully engaged audience, and so it's really been terrific to be part of all of this. I'm pleased to be facilitating this very last session that we have with our panel, and it's really going to be in two parts. The first part is we want to introduce our thoughts about how Sedgwick is going to approach the implementation of SB 863 and kind of what we have underway. And then secondly, we're going to ask our panel here to answer some questions about some of the reforms. Some of these are questions that may not have already been addressed today. So on our panel, we have Cindy Parker, who's Vice President of Operations and based in Northern California out of our Roseville area. We have Eddie Canavan, who's head of our work comp practice group and has been very instrumental in putting this entire session together for all of us today. And we have Joanne Munch, who's Vice President of Client Services. So we're representing operations that are dealing with implementation and what the claims folks do in the audience with all of this legislation. Eddie, who represents our practice group and helps us develop our best practices and integrate that with industry practices. And Joanne, who represents client services and a lot of the data analytics and how we're going to be working as a client advocate and reporting out to our clients. So we're first going to start with Cindy to talk about the implementation of what Sedgwick has related to SB 863.
Thank you, Sally. So, as we've all seen today, a 170-page bill with 70-some-odd changes to the system contains many new opportunities and challenges. So at Sedgwick, we're approaching these challenges through a use of a combination of resources and media. So, for example, our practice lead group, Sedgwick University, our defense attorney partners, our IT group, and, of course, our colleagues. On October the 1st, we started a weekly series of emails to our colleagues entitled SB 863 in Focus. These emails provide overviews of the key aspects of the bill for our colleagues, and we're going to continue them through the end of the year. In addition, Mike Sullivan has generously provided his book on SB 863 to all our California claims colleagues. And I don't know if you can see this, but you know it's a good book when it requires this many colored tabs, okay? This is more than in my labor code, so this is a good thing. So thank you, Mike, for that. Phase 1 of our internal training, the SB 863 overview, took place in October. Mike Sullivan provided 2 3-hour sessions, one in Southern California and one in Northern California, for our designated subject matter experts from our offices. The subject matter experts have the material recorded for them, and they are now delivering it to each of their offices. Phase 2 of our internal training, implementation and strategy, will take place in approximately mid-January, and it will be for all of our claims teams to really reinforce the changes that are required of SB 863. And we've also established work groups in all of our offices with colleagues from all of our offices to develop our own internal workflows. As you can imagine, there's going to be a lot of changes for us as well. So we have work groups for the independent medical review process, the independent bill review process, liens and fee schedules, the MPN, advancement of PD benefits, the supplemental job displacement voucher, and interpreting. And to tie all this together, we've put all of our training material, including an electronic version of Mike's book, on our internal Sedgwick SB 863 portal site for all our colleagues to reference.
Great. Thanks, Cindy. Obviously a work in progress and a lot to do, especially as the regulations get promulgated. As we move into the questions section of this panel, I guess the caveat I would say is obviously with 24 work groups to determine how this law will unfold, we still have a lot to learn about the law, and we will be modifying what we do based on, as the law unfolds. So we have some questions hopefully we'll be able to provide you some answers, and then we'll be asking our web audience as well as you here for additional questions that you might have. So I'm going to kick this off with a question just to ask each of our panelists what they think is the most impactful change brought forth by SB 863. So Eddie, actually I'm going to start with you from the practice, and then we'll go to operations and client services.
Thank you, Sally. You know, one of the most impactful areas of this reform bill is going to be permanent disability. As Mark outlined, it will increase costs by $510 million over the next 2 years. But there are aspects to the changes in permanent impairment that are positive. One is the whole elimination of the add-on to increase the overall award. As we all know, being in claims in California, most applicants' attorneys, when they file that continuous trauma claim, they include sleep, psych, and sexual dysfunction. So now that being eliminated from being able to increase the permanent disability award really should help in a lot of different ways, not only in just litigation overall, but also maybe saving the examiner some time to get to other things on their desk. And that's kind of hard to quantify cost savings there, but I see it as a huge benefit for our examiners, that now they will not get a lot of those applications just for the sake of trying to increase the award. The whole increase, 15% increase, decrease being eliminated, as Mark pointed out, there was 3 times more increases than decreases. You know, it was also going to be a positive, and it's going to definitely help save not only money, but again, time. Because if anyone in here ever had to administer that 15% increase or decrease, it was not an easy thing to do. And it really didn't do what it was intended. You know, if a injured worker retired, if they were terminated, if they resigned, then from the perspective of the California State Audit Unit, they wanted you to increase those benefits by 15%. So it really did not end up working really the way it was designed, so therefore it was eliminated. But one of the most interesting aspects to me of this bill is the fact that we will no longer have to advance permanent disability benefits if somebody returns back to work. And so, you know, in the past, we've advanced the entire amount of permanent impairment. We go to settle the case, and we ask the injured worker, will you please sign this stip? And the injured worker says, well, what's in it for me? And we say, well, nothing, because we've already advanced all your benefits. And so now we won't have that circumstance any longer. We can actually go to them and say, well, if you sign this stip, we can give you a lump sum payment for the permanent disability benefits that you're due. So what I'm hopeful is that that will result in our ability to get more claims settled quicker and actually get more claims closed sooner.
Thanks. Sosie?
Well, along those lines, my personal favorite, liens. Liens and liens. As we all know, probably far too well, liens are absolutely crippling the system in the state of California. You know, you've heard 500,000, I've heard 1 million, I've read studies that say there's 800,000 at the Workers' Comp Appeals Board in Los Angeles alone. You know, this is just bringing the system to a standstill. It's horrible for our clients, the claims costs are crazy, but there's another cost to it, and that's the fact that liens make it very difficult for us to close claims as quickly as we would all like. So I would say that I'm the most optimistic about that portion of SB 863. If it reduces the number of liens in the system as is projected, then we should certainly be able to begin closing claims much more quickly, thereby reducing both our clients' claim costs as well as administrative costs.
Well, Cindy took my personal favorite of liens. So my second favorite would be the cost containment opportunity, whereas today we don't have any controls in place to manage costs for interpreters, ambulatory surgery centers, photocopying, and home care services. So as we know, as we've seen in Mark's presentation, whenever you have an application of managing something and controls in place, you'll see changed behavior. So my hope is that we see changed behavior in those areas.
Thanks. So a question for Eddie. Do you think that there are any provisions of SB 863 that may be unconstitutional?
So there is the provision with independent medical review and independent bill review that the decision is binding. So it cannot be appealed to the Workers' Compensation Appeals Board unless there's a finding that there was some sort of bias or conflict of interest or some sort of factual error. So a lot of folks in the industry are discussing the fact that that could be argued that it's unconstitutional to not allow the applicant the right to litigate that issue before the Workers' Compensation Appeals Board. The whole spirit, though, of IMR and IBR is really to leave those issues with the experts, IMR with the physicians, IBR with bill review experts, and really alleviate the judges from having to review something that perhaps they're not experts on.
Thanks. Cindy, an operational question for you. If an injured employee is transitioned back to the MPN, if the claim was denied, excuse me, too much of a cold here. Let me repeat it. Can an injured employee be transitioned back to the MPN if the claim is denied but later accepted?
The answer is no. Refusal to provide care that is later found necessary by the Workers' Comp Appeals Board will jeopardize the employer's ability to require the employee to receive medical care with an MPN provider. In this circumstance, the employee will be able to continue treatment with a non-MPN physician indefinitely. The choice to accept or deny a claim will now have long-standing consequences on the cost of the claim due to medical control.
It's a big thing to take into consideration.
Absolutely.
I'd like to, Fernando, are there questions that our web audience has?
Yes, we have a couple of questions. One of them has to do with the lien filing fee. We know that back in 2004, there was a lien filing fee, and about a year later it was removed. The question is, why was it implemented, and then why was it removed a year later? And then the second question might be better answered by Michael Sullivan, which is, will the Sullivan on Comp be made available to the web audience?
So I'll go ahead and take the first one. So,
thank you.
So the filing fee was put in place. Unfortunately, they could not establish administratively how to get that fee from the lien folks filing liens. So unfortunately, it was abandoned and it was not pursued. We're hopeful that this time around with regulations that there will be a much more tighter process put in place to make sure that they have a method to collect both the activation fee and the filing fee. And we'll leave I think we have a mic on Mr.
Yeah,
Sullivan
Mike
back there.
Yeah, it's free to everybody. As many as you like. Oh, sorry. Yeah, it's free to everyone, as many as you like. Just come see me afterwards if you'd like, or give me an email, mike@mikeslaw.com, and I'll send you as many as you like. I'm giving away a few thousand.
Thank you, Mr. Sullivan.
Thank you very much. It's been very generous with our training. Joanne, a question for Client Services. How will Sedgwick assist me in determining whether or not SB 863 is reaping any cost savings?
That's a great and tricky question, Sally. So, as we have seen, it's going to be hard to determine out the gate. There's going to be longer-term opportunities for cost savings. So as in typical Sedgwick fashion, all of our work groups that we have put together are going to be focusing on areas that they're working on, working with your client services director to think about the areas that you want to manage and measure within your own organization. And then we'll look for opportunities of how to trend those from year over year as the coming year in 2013 unfold.
Great. I wanted to see if there are questions from our audience here. Sure, Sharon?
This is going to be more of a procedural question that you might not be able to answer yet, but so someone goes and gets the IMR and they say they don't need any treatment because IMR is just going to be treatment based. How do you use that then to cut off TTD or get them to P&S? How do you think that process is going to work? Because in order for it, I mean, if they say no, they don't need the treatment, what happens next?
So we can still go through the QME process for disputes per Labor Code 4062 that do not pertain to permanent disability or, I'm sorry, do not pertain to medical. So my strategy or my recommendation would be that if you have an IMR come back and say that no further treatment is required, I think if I understood your question correctly, then you utilize that, you go through the medical legal process, and you have a QME or an AME look at that. It would be admitted into evidence. They should be able to see it, and then argue that since no further treatment's required, the only reasonable outcome at that point would be permanent stationary status or MMI.
And I think I'd add, we need to be cautious. What's likely going to go to the IMR is an individual treatment request. So it may be, you know, for example, a surgery, and that ends up being decertified. It doesn't necessarily mean then that the treating physician might not come up with another strategy or approach. So I think where the IMR is for a specific item, you know, and I found that very interesting in Mark's slides, and I never doubt Mark, ever. But I thought it was fascinating to see in Texas how temporary disability went down, and how those, and I saw a lot of heads nodding, how that seemed a little intriguing to me. It would seem to suggest a change in behavior in the treating physicians, and perhaps that's what this will do. I'm a little skeptical. I mean, I think that the physicians will go back to the drawing board like they've done with utilization review and find another treatment to recommend. But perhaps if it's the final treatment request that a physician has, and now they're told that they can't have it, if maybe at that point a doctor throws up his or her hands and says, well, then they must be permanent and stationary, and maybe that's what stops the clock.
For client services, what is Sedgwick's plan to ensure their MPN partners will be compliant with the changes required by SB 863?
We're actually already working with our MPN partners to ensure compliance. Luckily, the effectiveness is 2014, but we are focusing on the areas of the medical access assistant and confirmation of physician. So we have those conversations in place, and those will be unfolding. But again, we have the year to also await for any fine-tuning of the regulations.
Okay, thank you. Any other, do we have some additional questions here from our?
Yes, we do. There's a question from a large national account asking, when will program managers be working with work groups on individual client programs to see how they can implement the reform? And then a second question that just came up right now is, what is the expected response time from the IMR? I think we addressed that earlier. I think we said 30 days. And is it the same time frame as a QME, AME? And the answer to that is no. So forget that question. So
program managers, is the question, Fernando, are program managers going to be working with our work groups?
Right.
Okay, great.
Yeah, so, and we don't need to wait for that. So the program managers, client services managers should be having their discussions now. It's a big buzz in the industry. A lot of us are still having these sessions, having a learning curve. Again, many of the fine-tuning details to be unfolded upon the writing of the regulations, which Christine tells us her holiday elves will finish in that by January, so we're looking forward to that. So we can start having those planning discussions now. Again, those individual measurements at the client level are going to be custom to those clients. And then our program managers will be bringing back those to our corporate level, and we'll be working internally with our work teams. We'll have some opportunities on a client-by-client basis if there's particular information to be tracked in our claims juror system, custom client tracking fields. But I would anticipate that in the year to come that we'll have some opportunities to talk about fields and tracking within juris. And Ed actually is on a work group now relative to releasing a lean module for our examiners to utilize.
Yeah, we're all very excited about that, that's for sure. A question. Excuse me, Eddie, any provisions of SB 863 that are effective immediately? And I think corollary to that is in discussion over lunch, I think there's an interest from our audience here, probably both web and in person, for probably a chart that can take the major provisions of the bill and identify when they're effective, kind of for which group.
Sure. So unlike SB 899 that had many provisions effective immediately upon the governor signing the bill, SB 863 does not. Most of the provisions will be effective as of 1/1/2013 for all dates of injury. Some of the MPN factors will be effective as of 2014, and then many of the provisions dealing with permanent impairment will be effective for dates of injury on or after 1/1/2013. I can go ahead and plug Mr. Sullivan's book again, Sullivan on Comp, because it has a very comprehensive list in the very front of the book that outlines all of the different aspects of the bill and when they're effective. So I highly encourage each of you, if you have not already done so, to pick up a copy of this book, because it's a very good resource to be able to easily determine what's effective when, and so that you can plan accordingly.
Web question. Currently, we are able to settle claims without an MMI report at the WCAB. Will that change with SB 863?
So I would say no. With everything that I've seen and read, I would say the answer to that question is no. You should still have the same ability to settle claims as you have had in the past. As long as you have an argument and you have your evidence in line, then you should still be able to try that case and try to come to a settlement as you would in the past.
Do you have a cell phone?
Not me?
Not me.
Okay, question. Thank you.
I went to a prior seminar on 863, not as good as this seminar, but but one of the defense attorneys had said out loud to all the adjusters in the room, "Welcome to your new nightmare." My question is for Eddie. Based on 863, do you see your adjusting staff a lift for them on their desk based on the new laws, or do you see it becoming more complicated for them?
Sure, that's a great question. So to contrast with 899, we had many facets that we had to put in place, like utilization review, the medical provider network, the whole 15% increase-decrease, the whole second opinion spinal surgery that is also eliminated by this bill. With this bill, lots of things are going to be administered by the administrative director. So the IMR, we have to send a request to the administrative director. IBR, send a request to the administrative director. The whole $120 million return to work fund, administrative director. So I do think that they eliminated some things that were procedurally difficult for the examiner in this bill and replaced them by taking some of the burden off of them and actually giving it to the state.
And I think like with SB 899, there's going to be that initial period, though, where we have to remember different dates of injury, and I think that's generally for the examiners the biggest challenge, and it makes it tough, you know, because you got to keep taking that hat off and knowing what it is. I think once we get past that, and I think this is a much shorter window than on SB 899, I would agree. I think there's enough offsets. It's still incredibly difficult to be an examiner in the state of California, but I do think there's some help coming.
Susanna? Well, just a moment here. Karen will give you the microphone.
Okay. This has to do with a comment that Mark had earlier regarding the cost of cost containment that has been going up every year, about 23%. So now, what about SB 863 will help slow down that pattern? Is it just the fee schedule, or what other areas?
So there's a lot of areas with 863 that I think are going to impact loss adjustment costs in a positive way. As Cindy eloquently outlined, liens is a huge component that costs us a lot of money to defend. And 863 is essentially eliminating the ability to file a lien, especially on an accepted case. So that is going to greatly help with minimizing loss adjustment costs for defending liens. Independent medical review, currently the remedy is to go through the AME, QME process. We all know that AMEs are not the most perfect way to get something solved. The reports can take months to secure. Many times you have to get more than one report. You might have to depose the AME, you might have to do an interrogatory. So with the IMR process being binding on all parties, you're taking that away from the system. So that should also help minimize some of those loss adjustment costs. And IBR, which ties back to the liens, given that now if the provider disputes, they'll have that second opinion that they can go forward with, then they can do the IBR. And again, the IBR is binding. They cannot go before the appeals board to contest it. It is essentially an order from the administrative director of the IMR as well. And so it's taking that prolonged litigation out of the system that should eventually help minimize and lower, at least slow down the inflation on loss adjustment costs.
Great.
I have a question regarding the potential spike that may come in liens at the end of 2012 in anticipation of all the lien claimants trying to get their liens in before 2013. What, from an operations perspective, is Sedgwick's plan to assist the adjusters with that anticipated increase? I know in going through claims reviews, a lot of these files are open liens only, and we're waiting for that. And I imagine the amount of calls they're going to field at their desk is going to increase exponentially. What's our plan to deal with that anticipated spike, if you will, in the lien resolution process that we anticipate prior to the 2013?
Yeah, that's a great question. We're disconnecting our phones. So thank you. We have a number of resources available to us. For example, we have a lien resolution unit within Sedgwick that has a great expertise at bringing liens to a resolution. There's a number of resources, but I have to tell you, I don't think that it's going to exponentially get that much worse than it already is. I mean, frankly, with almost 1 million liens at any given time in the system, I think a lot of them have been filed. I think what's going to be interesting is they're going to want to escalate settling them because they don't want to pay the activation fee.
Yep.
So actually what might be interesting, and I hope this is true, we might find some people getting a lot more reasonable with us and not willing to spread it out and push it to the WCAB because now it's going to cost them. So what I'm kind of hoping is maybe that's the trade-off and we get to resolve a few of them a little quicker so that the activation fee doesn't have to be paid.
And we also, when we had the regulations adopted back in May that dealt with being able to dismiss a lien for lack of prosecution, we had a campaign in the month of August called All Things Liens. And this entailed several self-paced modules for our colleagues to go over these new regulations, but also just in general how to negotiate liens in different circumstances like NPN, you are denied, et cetera, as well as providing them with job aids that were posted on our internal workers' compensation portal site for future reference. So we wanted to give them that education knowing not really what was going to come down the pike, but just with those other regulations. But it really, I think, assists our examiners now with some of the activity that they're seeing as a result of SB 863.
Absolutely.
I think it's an interesting question, Jennifer. One of the things that we can do in our offices is to track the number of incoming phone calls that come in through our phone system. We did this a couple of years ago in terms of just monitoring what are the number of calls that come in, and I was really quite astounded with the thousands of calls we get every month. I was guessing that maybe a good 50% or more of those were lien claimants. But I think one of the things that will be very interesting to do just on an analytical basis is to look at the number of calls coming in, post 1/1/13 and see how this drops off, because so many of lien claimants are kind of on rotodial and try to find any way into a claims office. So it'll be interesting to see what the impact is on a desk. I think you're raising a very valid point, and I think it's something we can measure.